Welcome, welcome, welcome. Good morning to those, a very cold morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everybody in between. My name is Dan Balkaran, as you see on the screen, and I'm an employment lawyer at Samfiru Tumarkin LLP, which is Canada's leading employee side employment law firm. Okay, so for the next half an hour, I'm going to be answering all questions employment law. Before we start, though, I'm just going to do a piece of housekeeping. As always, if you want to get a hold of us, you can do so. Employmentlawyer.ca, great website, lots of helpful materials there. help@employmentlawyer.ca and 1-855-821-5900. Okay, please submit your questions. We've only got half an hour. It's our first show of the new year. Glad to be back. Happy New Year to everybody. I hope everyone had a wonderful and safe holiday season. Okay, we've got one question while we're waiting for the others to go, and I can see that there are a whole bunch in queue, so should get to those shortly. Let's start with this one. I'm not going to identify this person because it would reveal who they are. The name would reveal who they are. Can I remove without consent? Excuse me. Can I be removed without consent from an indoor sales team that had good commissions to a door knocking team that sells outdoors and sells less, reducing your pay by 50%? It's a humiliation plus demotion. That's a great question. Okay, so your employer, through its actions, can de facto terminate you. Okay, many of you have heard of that. It's called a constructive dismissal. That's where the employer, through its actions, has terminated your employment. And there's two ways to get there. One is a unilateral change to a fundamental term of your employment, like pay, for example, but it can also be demotion, hours reduction, even sometimes a schedule change, depending on the importance of your existing schedule to your family structure and or other second job, other arrangements. The second one is a sort of general repudiation of your contract of employment by the employer, insofar as it has demonstrated it just doesn't want to be your boss anymore. I mean, your employer anymore. The best way to put that would be sometimes employers try to get you to quit, and if its actions are sort of commensurate with or are commensurate with that concept, then it can be a constructive dismissal. Although it's very hard to make out. You need a lot of evidence for it. But to your question, the important thing, I mean, there's two components to it. You hit the nail on the head when you said it's a demotion, which is humiliating, loss of prestige, very big in triggering a constructive dismissal with respect to a demotion. But I think the big one for you is reducing your pay, right? So you said your commissions are reduced by 50%. Well, what percentage of your overall pay is your commission? Sorry, I'm just trying to reduce the glare there. If your commission is 5% of your pay, a reduction by 50% of 5% isn't going to get you to a constructive dismissal. If your commission is 100% of your pay, then a 50% pay cut is going to get you to a constructive dismissal every time, well, almost every time. Constructive dismissals are harder because you have to get a judge to agree that the actions of the employer have terminated your employment. So if the judge was in yours, the judge say, yeah, no, I can't work here anymore. And so if the easiest way for you to trigger a constructive dismissal is if that pay cut is more than 20% of your total take-home pay. If it isn't, you're going based on loss of prestige, humiliation, et cetera, of the actual demotion. Now that's a lot harder. Demotion constructive dismissals are much harder to make out. So you're certainly before, and just important advice for everybody. If you think you've been constructively dismissed, don't say that to your employer. Don't take any actions to trigger a constructive dismissal, because if you're wrong and it's not a constructive dismissal, you quit and you get nothing. Okay. If you think you've been constructively dismissed by the actions of your employer, 100% of the time you should speak to a lawyer. It's too complicated. It's too difficult. You need legal advice to help you navigate the complexity of the constructive dismissal legal environment. If you need to talk to us about it, you can do so. And I don't know your name, unfortunately, or I can't say it. I recommend you talk to a lawyer right away. You need to talk to us. Again, employmentlawyer.ca, help@employmentlawyer.ca, and 821-5900. Thanks. Great question, though. I'm going to call this person B, again, because unique name, I don't want to identify them. My boss is not letting me take a 3-week vacation. He says I'm in sales, and if I leave more than a week, I won't reach my sales targets. So he says I can take 3 periods of 1 week in 1 year. What's the rule in Alberta? And I'm called in BC too, so unfortunately I can't. I'm not familiar with the rules in Alberta. There's a broad similarity between the employment standards legislation in each province, assuming you're provincially regulated based on your question. You have to get 3 weeks of paid vacation a year, has to be taken if that's what you're entitled to. If it's contractual, if it's in your employment contract. So, sorry, I'll back up here a second. The employment standards legislation in each province, if you're provincially regulated, contains the statutory floor over which or you're entitled to for a variety of different rights, including paid vacation. So you have to get 2 weeks of vacation in BC unless you've been an employee at a given location for 5 years, and then you get 3 weeks. However, your employer can also make your vacation contractual. So your employment contract can contain a term about your vacation pay or your vacation. And if it does, then that's where as long as it's over the minimums of the Employment Standards Act, or in Alberta's case, the code, Employment Standards Code, then that's the amount of vacation you'd be entitled to. But there are lots of, your employer just has to give you the time off that is legally required to, either by contract or statute. But it's not under an obligation to give you a 3-week vacation. That's something you have to come to an amicable arrangement with your employer. And you know, some employment situations don't allow for it. It's very hard, for example, for lawyers to take a 3-week vacation. 3 1-week vacations or something like that is much more practical for a lot of lawyers. And I'm sure doctors are the same way, and you know, lots of professions and situations where it's a high volume, high demand business. So, you know, in your situation, no, I don't think you can force your boss to give you a 3-week vacation. I think the solution is amicable. As long as your boss gives you, your company gives you the 3 weeks paid vacation in a year, then that's all you're entitled to, assuming that's the amount that you're entitled to. Maybe you can reach some sort of compromise with your employer. Maybe you can go for 2 weeks and then 1 week at another time, or maybe 2 1.5-week vacations. But I would urge you to come up with a compromise solution if you can with your employer. But I don't know of any mechanism, and maybe there is in Alberta, but that can force your employer to give you the 3 weeks. I also, just as a note of caution to everybody, if you're trying to use the law to force your company to agree to something it doesn't want to agree to, that's going to be, it may be that the relationship between you and the employer starts to sour faster than you perhaps like. So, you know, before you use the hammer of the law or on a business that you want to continue to work for, just think about the overall relationship, and if you want to resort to that degree first, because it can sour the relationship once you start talking about employment standards and human rights and legislation. It can go quickly. So just be careful with that. Mike asks, I'm paid a base salary plus commission per product sold. Can my employer change the commission structure in a way that if you don't reach the sales target, the commission is targets the submission, the commission is reduced? It's a huge, well, I don't need to say what kind of business it is. Listen, this is the age-old battle between employer and salesperson. You know, before I was a lawyer, I used to run call centers for major technology companies, and I can tell you, 20 plus years ago, still the battles were going on between commission salespeople and the business who wanted to forever reduce the commission of the commission salespeople. If your employer says, we want to reduce your commission, here's your new commission structure, commission agreement, sign it. You don't have to sign it, okay? But if you don't sign it, you don't agree to it because you want to stay on your existing commission, one of a few things is going to happen. One, they're just going to let you continue as usual under your old commission structure. Two, they're going to fire you. Three, they might give you working notice to implement, because they can do that, the commission structure. There's and just overall, four, the relationship between you and the employer is going to be soured. But if the commission change that they're trying to impose on you is taking you from $150,000 a year to $60,000 a year, yeah, you're probably not going to want to sign that, depending on what the rest of your employment contract says and what that allows you in terms of severance. If you've got a situation where you've been there for 15 years, you're making 100,000 base and 100,000 commission, and they're trying to reduce your pay by 50%, and your employment contract doesn't otherwise limit your common law severance, you're probably going to want to talk to a lawyer immediately and not sign that employment contract. So, Mike, it really depends on the facts of the situation. How long have you been there? What does your employment contract say? How big a reduction is this in terms of, sometimes commission reductions are quite often, they're just, they're 8% of your overall pay, in which case it's unfortunate. But if you're still making more there than you would make at another position on the open market, maybe you just take the hit, right? So, Mike, you need to talk to an employment lawyer. You need to have the individual granular facts of your situation assessed. As you can see on the screen, you can get a hold of us if you want at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay. Sam asks, what is one method for an ex-employee to confirm whether a previous employer may pursue a back taxes lawsuit or anything similar? So I am not a tax lawyer, and so I'm not going to address that question, other than to say I don't know why an employer would, again, I'm not a tax lawyer, but I don't know why an employer would pursue a back taxes lawsuit. It's the government who wants the back taxes that were unpaid, right? So the employer may have not withheld the correct amount at source, in which case the government's probably going to go after the employer and the employee. And maybe the employer has an action against the employee for the amount of taxes that it was supposed to remit and didn't. But I think that's probably what you're getting at. But you need to talk to tax lawyers. So I'm not going to say anything more than that. Chrissy asks, my employer has told me I need to wait longer for a return to work after parental leave. They keep flip-flopping, saying I won't be coming back and I have to wait longer. What should I do? Well, listen, if you are entitled to return from a parental leave, and if they're not allowing you to return, then it's effectively a termination of your employment. And you could probably treat it right now as a termination of employment. I mean, I know they keep flip-flopping, but if at some point they said, well, you're not coming back, then you can treat it as a termination of employment and pursue your severance. Now, if you'd want to do that depending on what your employment contract says. If you didn't sign one, you certainly want to do it. You're going to have a human rights complaint no matter what. Now, human rights damages tend to be small, but you can combine it with I don't know if everyone heard that or not. I'll just take care of that. Human rights tend to be small, but you can combine it with a lost wages claim, which makes it bigger. But yeah, they have to let you return to work from your leave. If they haven't done so, and put you back in your old position or one that's substantially similar. If they're not doing that, then you have certainly a human rights discrimination claim, and also perhaps a wrongful. Well, you can treat it as a termination and claim wrongful dismissal. Could be very lucrative. Again, common law severance, if you're entitled to it, depending on how long you've been there, could be as much as 24 months of severance. So, Chrissy, I know I sound like a broken record today, but you should talk to a lawyer. If you want to get a hold of us, you can do that at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, Peter asks, what happens when you are on disability for over 2 years and now you want to return back to work. Okay, so sort of a conflation of different concepts. So if you were away for a medical reason from your employer, you're on medical leave. Okay, the disability portion is just how you get money from an insurance provider while you're away on medical leave. So the question is, I've been on medical leave for 2 years and I want to return to work. Well, hold on a second. I think there was more to your question. So first part of your question is, what happens when you're on disability for over 2 years? Now you're ready to return to work. What happens when you're on disability for over 2 years? I'm paid salary, but the job I once had is now not available, but you'd be working a different job within the company. So the company has to put you back in substantially the same position that you were in prior to you going on your medical leave. It doesn't have to put you in the exact same position. And so the question is it substantially similar? Is it reasonable? Is it not reasonable? Okay, and you have to take a look at that. The company is, it's dealing with a 2-year absence, so it's a lot of companies can't, smaller companies especially, can't take that kind of hit. They have to rehire into your position. All of a sudden, you say you want to come back, and then the company is trying to scramble to make it work. So is it actually trying to make this thing work for you? And would it be unreasonable for you to not accept the accommodated role? So, it depends on the situation, and it's going to be very fact specific. So it very much depends on what your situation was, what your capacity is now. So quite often when there's a 2-year absence for a medical leave, the individual comes back and they're not going to be at full capacity. Maybe one person comes to mind who I spoke to who had a back injury and was a construction. Hope everyone can still hear me. I just got a message that said my connection was lost. So okay, you guys can still hear me, great. So in that situation, it's a construction job. He was a construction laborer, and now he can't do the labor above 65% of what he could do before. What is the company's obligation there? And it gets into it gets quite complicated when you talk about, because you were away for 2 years. Now, if you're away for a year and a half ish, maybe year and a half about 2 years. If you're away for 2 years and there's no medical possibility of you returning anytime soon, the employer can claim that your employment has been frustrated, and that simply means that all of the employer's obligations to you are extinguished by your medical absence, we'll say. So I don't know if they've attempted to claim that here in this situation, Peter. It sounds like they haven't. I would give a real good think about what kind of job they're offering you and how far removed it is from what you were doing before. Is it substantially the same pay? Is it the same pay? Is it a humiliating loss of prestige? Like, exactly how big is the difference, right? Did you go from manager of customer service to janitor, or is it something else? And then if you think that this is not something you can accept, or the difference is too great, you should talk to an employment lawyer right away to see if you can treat it as a termination, what you can do to try to trigger your termination and severance in that situation. And again, if you want to reach us, you can do that at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But those ones, where you're coming back from a medical leave and the employer offers you a position, but it's not the same as the old one, those are really tricky. It depends on the details of what they're offering you, what you had before, the nature of your capacity post-injury or post-medical leave. It's the nature of the business itself. Is it a gigantic conglomerate, or is it a 5-person shop? It's very complicated. So definitely you want to talk to a lawyer, Peter. I don't know this person's name either, so I'll just call them AC. My employment contract has a 2-week notice period. The job has been very difficult and is impacting my mental health. I would like to resign effective immediately, but I'm worried about the possible repercussions of not giving proper notice. Would not giving a notice period cause me any problems? Okay, it's a really interesting question. So depends on the nature of your position. So broadly speaking, no. You should give your 2 weeks. If you can't, you might want to get a doctor's note and say that you're medically unable to do it, and then give them the 2 weeks. I have heard of a situation where the employer claimed that by not getting the proper notice, it was materially and financially affected, and then sued the employee for its alleged losses. I don't think anything came of it, but it has happened. I have seen it happen, especially if the you said your employment contract indicates a 2-week notice period. Your best bet might be to, and it depends on your situation too, right? If you're a C-suite executive, you probably should give the proper notice, right? But if you're rank and file employee, sounds like you just started too, so you're probably going to be okay there. But an amicable, I always say amicable solution, but talking to your employer and just saying my health is being affected by this, I need to resign, but I can't do it. I can't give you the proper notice. I apologize. I can provide you the doctor's note. That might just sort of smooth the exit, so they don't take any action against you. Like, listen, I've only ever heard of the corporation, a company once attempting to, I'll just say, punish the employee for not giving the proper notice. What is their damage? What is their loss from you not giving the proper notice? 1 week of wages, 2 weeks of wages. There'd have to be, for it to be worth it for the employer to go after you, there'd have to be losses that to the business that were reasonably foreseeable. And if you just started, you're an employee lower down the totem pole, very unlikely. So broadly speaking, no, you're probably fine. But there is that one outlier that I encountered or that I have heard of. And if you want to really make it safe for yourself, you get a doctor's note and resign at the same time. And I think it's unlikely that the employer is going to take any action on you at that point. Peter asks again, can they increase my workday hours from 8 to 12 hours per day? And if I end accommodation, are they supposed to accommodate? Okay, so Peter was the one who is coming off disability. Well, so Peter, if they're increasing it from 8 to 12 hours, I assume that your days of work are shrinking from 5 to 4. Or something like that. 5 to 3.5 or what have you. So generally speaking, people want to do that because they get more days off. If you can't do it though, the question is, can you do it medically, right? 12 hours is a long shift. And if you're not healthy enough to do so, just provide a doctor's note saying you're not healthy enough to do so. But there is the risk of the employer saying, well, listen, this is core to the duties of the job that you work 12-hour shifts. If you can't do that, we don't have a position for you. And then you're in a dogfight over, well, did they terminate you? Did they do enough to reasonably accommodate your limitations following your medical leave? And again, what are the facts? I can't tell you how that's going to land. Those are very complicated. Those are complicated situations, and the one you're describing is complicated. Again, Peter, I would look at, what is the intent here? Do you think your employer is actually trying to get you back in the fold and doing its best, or is it just trying to make this so onerous on you that thank you, Sharon, I appreciate it. Former client of mine just said that I was a brilliant lawyer. It's very, very nice of you, Sharon. Where was I here, Peter? Are they really trying to accommodate you, or are they trying to erect a series of I don't want to call them barriers, but are they trying to make it so onerous on you that you just go away? And if your conclusion is it's the latter, then I recommend you talk to an employment lawyer right away and see if you can marshal your situation to trigger severance and or pursue lost wages and injury to dignity damages through the Human Rights Tribunal. If your employer is provincially regulated, which I assume that that they are. So, Peter, your situation's really complicated, and I think that as much as anyone else here, you should contact an employment lawyer. You can do so if you want to contact us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. So that's it for questions. We ended early today. Usually we've got a few more that I try to get done. Is that it? Going once, going twice? Okay, that's it for questions. Thank you for those questions. They're all great questions. We got one more. Khalid asks, I'm on disability now. I've contacted my union, and Khalid, I'll stop you right there. If you're subject to a collective bargaining agreement and are a member of the union, I can't assist you in this forum. You need to talk to your union representative and go from there. I don't practice that area of the law, so I'll direct you back to your union representative. Okay, thank you everyone for your great questions. I'm back. I will be doing this every 2 weeks, same time slot, Friday, 10:30 Pacific. And join us on Monday. There we go. We've got Chris Justice, Monday, January 15th, 1:30. Join us then, and he'll be answering all your questions, employment law. And otherwise, I'll see you all in 2 weeks. Have a great and safe weekend. Thank you.